Welcome to CAM Radio, an Ahead of the Curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned. Enjoy listening.
So dear friends, a few months ago, and where is Vandana? I don't spot her also. I got a call from Vandana. CAM wanted to do a session on the 3 new criminal laws in Delhi. So who can say no to the most powerful solicitor couple and firm? So although I have known Vandana and Cyril for long, I was aptly reminded last evening by my friend Gautam that senior counsels can't say no to solicitors. We sing to them for our supper. So of course I agreed. And I was told to be a keynote speaker, so I said fine. As time passed, I kept inquiring, what would you like me to speak about and for how much time? Finally, last evening, I was told 15 minutes. And I reflected 15 minutes on 3 new laws. What should I tell you, which has taken me over 40 years to learn, and I'm still learning, and summarize in 15 minutes? The foundation of the entire criminal justice system of over 150 years was supposed to be changing, or so it is believed. And I still struggle to understand all its nuances. What did CAM really want? On reflection, I think they wanted to know, was this necessary? Was this appropriate? Is this adequate to do the job? What harm can this change bring about? How do we gear up to meet the challenges of this change? We are 75 years into independence. Governance is the motto and mantra of every new legislation. We are told we are in Amrit Kal, that is a golden era, a period for welcoming new technology to improve the lives of citizens and bridge the gap between citizens and countries. The IPC, CRPC and the Evidence Act were creatures of the 19th century. Starting from the 1830s, the country was in disarray. We had the East India Company, principalities, monarchs, the Portuguese, French, and Dutch, who ruled all different parts of the subcontinent. So as the British government started increasing its stronghold over the East India Company and the rest of India, it started the much needed process of consolidation of these laws. The offenses changed from region to region, and so also their ingredients. Procedures for investigation and trials were not uniform. Evidence was a motley set of rules which were applied differently in different courts. A person who jurists describe as a visionary, but others as a colonialist, Lord Macaulay, was tasked with the first law commission, along with other respected judges and jurists, to start the process of codification. Between 1830 to about 1900, 70 years, we got the IPC of 1860, we got the Evidence Act of 1872, and we got the CRPC of 1898. 75 years of experience of the CRPC, and we got the CRPC of 1973, and 125 years from 1898, the first CRPC, we now have these 3 laws, the BNS, the BNSS, and the BSA. Well, as a practitioner of this law, I will still have to learn to say them. Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam. The old laws stood the test of time as living laws, evolving with the evolution in society and governments. They have lived well past our independence. But these were laws of the physical world. A quarter century into the 21st century, quarter century into this period of the 21st century, we have lived past the uncharted and largely ungoverned internet explosion, and we are now in a similarly uncharted territory of artificial intelligence. And if Cyril had his way, he would have had a computer or a robot speaking to you today. But I'm grateful to him that he still cares for humans and senior counsels. But as he himself mentioned just a minute ago, but not for long. The question which stayed with me was, did we need a replacement of the 3 laws from the physical world again to a physical world? When in fact, the world is phygital and marching towards fully digital. Obviously not. These so-called new laws are largely still for the physical world, and I'm sorry to say, a pretense for the digital world. The BNS, and this is demonstrated by the laws themselves, the BNS which is translated from, as Cyril gave the statistics, 511 sections of the original IPC to now 358 sections, has essentially only 19 new offenses, mostly borrowed from other criminal laws. So you have nothing new. The Evidence Act, the BSA, has basically two new sections and a few broadened definitions, particularly of document, which we'll come to, and both of them referred to them, and I think Ankush is going to deal with that. The BNS has a maximum changes to procedural law in an attempt to tackle the problems of delay in trials and quality of investigations. In the physical world, our biometric basically remained on our bodies. Now, these are the problems that I'm just sharing with you. We carried them around with us. In the digital world, our biometrics are now stored with government and authorities, both public and private. In the physical world, our biometric could not be copied easily. In the digital world, our biometrics can be copied by you and me. In the physical world, handwriting and fingerprint experts used to be humans. In the digital world, technology and machines are our experts. The biometrics now extend to voice, face, and retina apart from DNA. But the crimes have become anonymous and can be committed without being at the scene of the crime. The offences are now prefixed with the word cyber. The Ministry of Home on the National Cybercrime Reporting Portal has identified new age offences such as cyberbullying, stalking, sexting, email phishing, email hacking, impersonating profiles, online and social media crimes, online job fraud, online matrimonial fraud, intimidating emails, online gambling, and online trafficking. But is the BNS geared for this? Clearly not. In fact, none of these offences, which are defined on the portal of the Ministry of Home Affairs, are in this new legislation. The only reference to cybercrime is in the offence of organized crime, but without a definition of what is cybercrime. Is the BSA geared up for the realities of the digital, phygital world of crime? Clearly not. Document in the physical world was generally related to paper. In the digital world, under the BSA, it has been broadened to include voice and moving images, apart from, of course, the electronic record. But the biggest challenge is ensuring the genuineness and authenticity of such documents. Undoubtedly, there is a general presumption of human honesty which drives the legal process, including the evidence law. But society has evolved, and generally, stakes are much higher in commercial and criminal litigations of the type that all of you here deal with. Fabrication of evidence without detection is now very easy. Considering that most documents are now electronic and no longer printed on printers, but are now scanned images, there's virtually no footprint of a forgery. If fabricated evidence is already stored on your device, and this is very important in the context of the certification, if fabricated evidence is already stored on your device, what is the effect of the Section 63 certificate, or what they call now require a hash value report? The 63 certificate, as Gautam explained, is actually a certificate about the functioning of the machine, the computer, by an operator who claims to have knowledge about the functioning of that machine and can certify that that machine was working well. But if the criminal has already inserted a fabricated document in that system, the computer operator cannot say anything, because he can only say the system was working well. A hash value report, which I learned because this is not my subject, and now we all need to learn technology, is only a report which, and I think Gautam is a real technical expert here, which is a report where you take out this document from your machine. So a forensic investigator or an investigator will take out this machine from your system, put it into another software which has an algorithm which generates a hash value, and that hash value report comes out. All that it does, it protects an investigator, because when he tenders that document in court, it will be the same original document that he took out. It protects him. But if the original document which he derived was itself a fabricated document, then neither the 63 certificate nor the hash value can tell you that the document itself was originally fabricated. I was at this stage pause and probably go beyond this to tell you about some other realities. Some of you may be knowing it, but it's a learning for people at our stage in life. Youngsters know it a lot more. But there are now, particularly in the world of deepfakes, there are softwares which do voice cloning. And I think some of us know that the voice cloning is so close or virtually as good as the original that it's not going to be easy for somebody to disregard that who has actually said those. Is it Mr. Amit Desai who has said those words or not? You then have software, and all of this is just available. You Google it and you'll see it. Software where you can fake a WhatsApp conversation. You can fake an iMessage conversation. So imagine that in a contractual dispute, you have one side which has a document in its system with a purported WhatsApp conversation with the counterparty or an iMessage with a counterparty, and there is a dispute in relation to that particular document. And that document is actually then taken out of the system. You got a 63 certificate, you got a hash value certificate, and you then tender it in evidence because it's now under the Evidence Act, the BSA, a primary evidence. And it's admissible. So how do you actually deal with this? Because in the original world, you actually had a physical document, you had a witness who ultimately was familiar with the document, who went in the witness box and proved that document, it was admissible as a primary document. But this particular document will actually go into evidence not from the person who has actually prepared the document, but by a computer operator who gives a 63 certificate. This is how the system would now work under this BSA. I mean, I can go on, but I've got my 15 minutes, but I've already gone beyond my 15 minutes, Cyril. That's why I said I'm coming to some of the other things. Let me turn to BNS. These are just stark examples of what Cyril said is not a political conversation. But I think when you deal with the criminal justice system of a country, I'm not talking about politicians, but a conversation is necessarily political because it deals with the polity of our country. And therefore, it essentially is a political conversation. And I feel strongly about it only because this is what I practiced. And I can see the absurdities of what's there in some of these things here. So I can tell you, homosexuals can now sexually assault another and it's not an offense. Why? Humans can have carnal relations with their pet animals and it's not an offense. Why? Because we abolished 377 and never re-enacted it. This is the march in Amrit Kal, and I'm sorry to say this. A local police officer can charge a person as an economic terrorist because the power to register an FIR for terrorism is now with a local police station. Unlike the TADA, the POTA, and the UAPA, where there were specialized agencies which would register and investigate those offenses. Now, the UAPA, it is the NIA. So, local police officer anywhere in the length and breadth of India can actually, I don't know whether you would understand anything about terrorism, and somebody goes to him and says, here is a complaint, and we all know the law on complaints. Lalita Kumari, you have to draft a well-drafted piece of paper, and some police officer says, this fulfills the ingredients of this section, registered, FIR. So these are the problems. But you've introduced terrorism into a legislation which is essentially meant to deal with citizens and not with nations. Because terrorism was essentially an offense against the sovereignty of a nation, essentially. But what you did was you transferred that into a legislation which deals with the ordinary people. You then, in this definition of terrorism, you introduce the concept of economic security of India. But you didn't define what is economic security of India. So in the UAPA, there is a definition of economic security. But in this legislation, there is no definition of economic security. So I sometimes shudder to think that in the system and society in which we live, where we see so much of misuse at the local level, at a local police station, and commercial disputes often get settled in police stations, and now you've just given a handle to people to now call their opponents in a commercial dispute terrorists, because you ever go and pay some local officer, he'll register you an FIR under the terrorism law. Economic security. And you don't define what is economic security. So somebody will come in and say, no, there's this commercial, there's such a large impact, as Gautam tried to suggest, that if a significant debt of a public sector bank there's a default, does it mean it's the economic security of India? Because these are all public sector institutions. So where does it start and where does it end? And there was a duty to actually define, when you introduce such serious offenses into a legislation which deals with the common man, to define so that the local police officer knows when to enter and when not to enter into the realm of such offenses. Take another situation which impacts business community. If George Soros or his ilk enter the Indian financial markets and take bets which result in losses to investors, that too could be said to be an attack on the economic security of India. So what do you do with all the SEBI regulations which deal with all kinds of situations and where short selling is permitted? George Soros short sold the currencies of countries. So how is that an economic security of India? So commercial issues will come into the realm of terrorism, which has some very serious implications, and a local police station can register an FIR. Take another situation, banking defaults. Gautam mentioned that under organized crime, and organized crime, again, was a separate legislation. Specialized officers who investigated those offenses has now been brought into this particular statute again. There are lots of other problems in relation to all these, which I'm not going to touch upon right now. There's a lot to talk. But within the definition of organized crime, they made one change. Makoka was the original legislation. Makoka was Maharashtra Control of Crime, Organized Crime Act, which was a starting point of these legislations, which came state legislations across. And they essentially intended to deal with the underworld. So the original definitions of organized crime in that legislation, if you analyze them, were involving an element of violence. In this definition of organized crime, apart from the elements of violence, they brought in specifically economic offenses. And not only did they bring in economic offenses, they defined economic offenses. And they included some of these sections which Gautam told you about: criminal breach of trust, falsification, etc. But interestingly, expressly they've introduced bank defaults in the definition of economic offenses. So now visualize. I don't know if there are any bankers here in this room. No bankers. I'll give them an idea of how to recover quickly. Faster than the process today. So if you have a consortium lending and there's a default, another willful defaulter, and if it is so strategized by a good lawyer that every one of those members of that consortium will file separate FIRs at different points of time. And let me tell you, it does happen as we speak. There are several cases where this has actually happened. And thereafter, there are separate charge sheets which are filed. Then let me tell you that some of you may be familiar with the definition of organized crime. The requirement of organized crime, which is a continuing unlawful activity, you need 2 charge sheets within a period of 10 years for which cognizance is taken. That's all you need, 2 charge sheets. So if there is charge sheet 1 and cognizance is taken, and 3 months later charge sheet 2 and cognizance is taken, then you come within the definition of organized crime. So a bank default in which a smart set of bankers will go and file these 2 charge sheets will implicate that willful defaulter or defaulter into a charge of organized crime. You always related organized crime to underworld activities. But I'm sorry to say that I think a lot of you people in this crowd who are never ever dreamt that you could be part of an organized crime charge might soon find yourselves facing such problems. So this is another example of this statute. Oh, the first thing, I don't think I even need to narrate that if you are charged with terrorism or organized crime, I think you may as well shut your business and go home. Because I don't think anybody is ever going to lend to you ever again. You could have still got away with a CBI prosecution, but the moment you have organized crime, nobody in this planet will lend you a single dollar, whether it's in India or outside India. So that is the impact of a charge of organized crime or terrorism. It's the highest form of criminal activity that one sees. And that is the reason why the provisions in the specialized legislations are draconian provisions. But to bring it here and to say all of you, that's why I said the implication of all that is that Cyril Shroff is seriously thinking of setting up a separate practice area. I'm only saying that all those which close shop and go home, they won't be able to afford your fees. So this is the impact of some of these things that are there. There's another area which, now I'm just running into the other legislation, BNSS, the Nagarik CRPC equivalent. So there are many problem areas. They try to suggest that they'll tackle the problem of delays and better investigations. And whilst they have put in some timelines, as as we now march into this legislation, this is like the Arbitration Act, which said, 180 days. I mean, there's no hope that any of those timelines which are being suggested in this provision are ever going to be met. Some of them are 30 days and some of them are 60 days, but it's just impossible in our justice delivery system. But the one area which is very, very worrying is they put a timeline for delivering of judgments. 30 days with an extension of 15 days, 45 days. And I cannot imagine, and I'll just take the example of people here, a lot of you would be familiar, is take the 2G case, or you had the Commonwealth case in Delhi, you had the 2G case, you got the coal scam. All these are very, very serious crimes. But just ascertain that from the date of the closure of the evidence till the date of judgment, how many days did it take for a judge to appreciate the evidence? The witnesses ran into several hundreds. The documents ran into several lakhs. For a judge to appreciate the evidence to determine the guilt or innocence is not something that is easy. Just to read the documents takes so much time. And you just have to see the dates. And this legislation expects that in these complicated cases, that a judgment of conviction or acquittal should be rendered within 30 days. Impossible. We then have another very peculiar provision, but this is again very worrying, so I'll just bring it out here because I thought I'll use this as an opportunity to try and tell you where this legislation is going and why we need to be careful, because that's one of the things that Cyril wanted to say is, there are a lot of routine provisions, but I think it's about how you start reflecting on this statute and read it in greater detail. So there's another provision in the BNSS, which for the first time introduces conviction in absentia. So the law so far dealt with recording of evidence in absentia to protect the evidence that is collected. But we have now taken it to the next level to say that if there is an absconder, then you can actually convict him in absentia. And he doesn't have to be in presence of the court. So in that sense, if there is a proceeding, and there's again a huge debate that will happen as time passes, is can Mehul Choksi or a Nirav Modi be convicted in absentia? It's something which just shocks your conscience that in a society in which we've lived with the umbrella of Article 21 and all our constitutional rights that we believe we have, to have a provision that was legislated to say that I can be convicted in absentia because I did not appear before the court. And there are, of course, some criteria and conditions that is applicable for more serious offenses, but it's anathema to any principle of natural justice. What does it do to the extradition law? Because there are I'll deal with it at two levels. What does it do to the extradition law? Extradition law has been part of international treaties and international obligations. So if you can now convict a fugitive who is outside India in absentia, you don't need to extradite him. All that you need to do then is to send the judgment of conviction to the country where he is, and all the treaties will provide that if there's a judgment of conviction, he must be picked up and sent. So you've now effectively rendered the entire extradition law irrelevant. You rendered international obligations in many ways irrelevant. So Julian Assange, just to put it in context, if he had this prosecution in India and who fought for transparency and press freedom, or others who fight for political rights and political freedoms, could be targeted if they are in this country and there's a prosecution launched and he can be convicted in absentia. And when is a person an absconder? I mean, there are some conditions and criteria, you can check it up. But essentially it requires 2 unexecuted non-bailable warrants within a period of 30 days. And that's it. But what is important is this provision applies not just to fugitives who are outside of India. Even within India, if there are 2 non-bail warrants unexecuted issued within a span of 30 days apart, and you do not appear before the court, you can be convicted in absentia. So these are not just about an offender outside India, it's about a domestic. And anybody who has had in your organization, any criminal cases, will know the problems of serving of a non-bail warrant of arrest in this country. There are lakhs of non-bail warrants of arrest which are pending in the system, not being just lying around. Attempt to suicide, another example. If lawyers decide to go on hunger strike to oppose and prevent the Bar Council of India to not allow foreign lawyers to practice in India, Let me tell you, if you read the section carefully, it may amount to attempt to suicide. So Lalit, be careful. Don't ever even attempt it. You'll be in trouble. So I've undoubtedly simplified some of the examples here, but the risks are real, as the provisions are not only vaguely drafted, but have some provisions unnecessarily being introduced, which will result in endless litigation and unnecessary harassment. Is this what we wanted in this 21st century? Thank you.